Good afternoon, everyone. This is Becky Pearson, and I'm a partner in Venables Government Contracts Practice. And I'm so pleased with my colleagues to bring you Snatching Victory, Lessons Learned from Recent Bid Protests. And with me, I have Emily Unash. She's one of the rising stars in our government contracts group. She's a senior associate who works on, I would say, the most important protests we have in our office, and she's leading a team typically of other associates as well, and having them and herself review the record and prepare initial drafts. So she's very experienced in the strategy of protest as well as the actuality of the records that we're looking through. And I'm also pleased to have Caleb McCallum. He's a associate who's a great litigator. In fact, we share him with the litigation group, and he also has had good experience on bid protest. When we were sitting around and figuring out how best to present recent protest information, we realized that usually in every protest, whether we're representing the intervener or whether we're representing a protester, there is a story there about what got done right or what got done wrong. And typically it might be a little bit of both, that maybe the government could have written a clearer solicitation or the contractor could have paid more attention. By way of background for myself, I was an active duty judge advocate in the Air Force for 10 years, most of which I did in procurement, which meant I was a program attorney sitting on source selection panels, advising them on how to comply with the solicitation, actually taking a look at the solicitations typically also and making sure that there weren't ambiguities that we could pick up in those solicitations. And then I worked on the trial team in defending those. Obviously, since being at Venables, I've done a lot of bid protest. And we realized that a lot of it really goes back to fundamentals. So what I'm going to do is I'm going to kick off this presentation by talking about the fundamentals, and then we're going to get to Caleb and Emily are going to take us through some of the very specific lessons learned on recent bid protests. So the most fundamental thing is to get the government what they want, and we're assuming here we're mainly talking about best value procurements. We're not really doing sealed bidding or low price technically acceptable, although there can be protests involved there. But if you look at FAR 15302, it says it right there. The objective is to select a proposal that represents the best value. And well, how do you determine what that is? Well, gosh, you've got to read the solicitation. And actually, if you're a sophisticated government contractor, you might have had an opportunity in the marketing phase or in the requirements phase to weigh in on a draft proposal and help the government understand what its requirements are, what's out there in the marketplace, the value that your company can deliver. But once that solicitation hits, as everybody on the call knows, you can't talk to the government anymore, and you've got to go through a very formal process, which is going to be the focus of what we're talking about. So let's talk about the key. This is pretty basic, but we also, again, find that a lot of the issues are because people don't really pay attention to the basics. So here we've talked about the key portions of a solicitation under FAR Part 15, but these key portions of a solicitation are also in commercial solicitations. They just have different section headings. So Section C is the schedule, and it tells potential contractors what goods or services the government's interested in purchasing. And so that also might be as part of an attachment of a performance work statement as well. So obviously you need to make sure that whatever you're selling complies or meets those requirements, and that you understand what the requirements are and look for those ambiguities in the schedule or in the statement of work and identify them to the agency early. I'll talk about timeliness issues later, more specifically with the forms, but the basic rule is if there's an ambiguity, my preference is to identify it early, especially if it's something that might make a difference in whether or not you are understanding your proposal is giving the government what it needs. Section K is the reps, inserts, and other statements. Many of these are standard, but sometimes agencies will sneak those in, agency-specific ones, Those might include things that are typically responsibility-related requirements, but that they want to see addressed in the proposal. And then you need to make sure that whatever those are, of course, you can meet them. And the biggest sections for bid protest are Section L, or instructions, conditions, and notice to offerors or respondents, which are going to tell the offerors the information that they have to provide in their proposal or their quotation. And then Section M, which is evaluation factors for award. And of course, in a commercial context, it might not be Section M, but there'll still be evaluation factors for award and a best value. Ideally, those sections, the instructions and the evaluation factors, map perfectly. If they don't map perfectly, ask questions and understand, especially if you believe it's an area that's going to be of significant importance for the government. And then, of course, there's solicitation clauses. And it's really important, actually, to, early on, if you can, go through and take out any clauses that you think don't belong there. Because we're talking about protests now, but as good client counseling matters, you want to get out clauses that you don't need to comply with and that might drive your compliance cost. Because that also gets down to what are you going to have to do to perform. And if you're not planning on performing clauses that you think don't apply, just the better thing would be to get them wholly out of the contract. So we're going to move on to, what does the government look for when it reviews a proposal? Well, it should be telling you that when in Section L, in those instructions to the offerors. And you're going to want to make sure you do some sort of white glove treatment where you have somebody do a matrix for your organization for every requirement, for every data deliverable that has to go with your proposal, that you've done that. And that includes reviewing your pricing. Did you price everything that they asked? Did you price it in the way that it was asked? If they ask you to map your labor hours to particular sections, have you done the mapping? If you're not sure if they're asking you to map, maybe that's something that you need to clarify up front, although, again, we'll get to the strategy of what you do clarify and don't. And does your proposal demonstrate a good record of past performance? Another key strategic issue is, is this agency going to consider the past performance of your team members? If so, and you don't have a lot of experience, you can perhaps get that experience with a great team. And if so, and you have great experience, make sure that your team members have not only great experience, but good past performance ratings as well. And then finally, of course, you better be eligible to be submitting a proposal. If you're debarred, suspended, or proposed for debarment, you can't submit a new proposal. So you need to be responsible in that way. And also, as we talked about, if there are responsibility factors that you need to meet before award, make sure your proposal addresses those. So that brings us to, what are the strategies for a winning protest? And that really is going to be very dependent upon the particular offer. But when I say that, what I mean is this an important client to you? If it is an important client to you, is this an important procurement to you? If it's an important client and not an important procurement, maybe you don't protest even if you think you have great grounds. If it's a company protest, you're probably going to protest. But what you need at the kernel of it to file that first protest, whether that's at the GAO or the agency or the Court of Federal Claims, is you need to be able to articulate a factual basis for the government having unreasonably or irrationally evaluated your proposal in a way perhaps that's inconsistent with the stated evaluation criteria or that's inconsistent with law or regulation. And although I'll get in a later portion into what the different technical standards are for that review, it is a deferential review to the agency. And so whether you're going to the agency or the GAO or the court, you're going to need to show that there's that unreasonable rational conduct. And it needs to be based on a fact. It doesn't need to be perfectly proved because you're not going to have the record yet. But it can't be based on mere speculation. So, for example, at GAO, if you go in and say, on information and belief, I have a reason to believe that we have a good protest ground, that protest ground is going to be dismissed. But if you go in and say, based on these particular facts that I know, I have this protest ground, that should be good enough to at least survive a motion to dismiss. And of course, in any protest, you have to be able to show and explain the harm to your particular protest. So you could have the agency dead to rights they did something horrible and stupid and wrong, but if you can't show that it harmed you as an offeror, then you can't demonstrate protest. For example, a successful protest. For example, if you're an offeror and you scored the highest possible score in an adjectival rating, but you had one weakness, but you're significantly higher than somebody else, going in and showing that you could eliminate that weakness won't necessarily put you in a position to receive the award if it's not going to move the needle much. So it's important with your initial protest to demonstrate the harm and show that but for that agency error or unreasonable evaluation, you would have a substantial chance of receiving that award. And that's called demonstrating competitive prejudice, and that has to be in any successful ground. We've talked about the agencies trying to get protests dismissed. That is very common at both the GAO and the Court of Federal Claims. And it's important, very important, to rebut that at the GAO because your protest grounds, the information your attorneys receive under a protective order are going to be based on the protest grounds you file and only on those protest grounds. That's different than at the court when, as long as you can state a viable basis of protest, you're going to get a fairly full record under the court rules anyway. At GAO, you need to have motions that survive that give you an opportunity to have a real protest ground that survives and gets you what you want. That's the other question that offerors really should be asking themselves and their counsel, and that counsel should be asking, which is, if I get the relief that I'm seeking, will I really legitimately have a chance at getting this award? And if the answer is yes, then it makes sense to file a protest. If the answer is no, even if you could file one, then you might want to reconsider whether or not to file. Another strategy understand whether or not going in you think you have a good basis to be protesting or not, and that this is one that won't hurt you strategically with the agency. The other strategy that we found works well, especially in the multiple award context, is if it's a large multiple award and there's a lot of protesters, see if you can, through counsel, contact those other people protesting and get a redacted version of their protest. Of course, you don't want to have collusive bidding, and it's very important that you do it through counsel and don't violate any competitive restrictions. But it's also helpful to see if other offers are getting rejected for reasons and having issues to the extent you can see it in a redacted protest that are similar to yours. And we found that very successful in certain instances in being able to, where an agency had a common thematic issue that impacted more than one offer, to having the agency take real corrective action. And when you're thinking about strategies for winning protests, you also need to know the odds of where you're going. At the GAO in 2019, only 13% of protests resulted in a sustain. But when you consider the sustains plus the corrective action, that was 44% of the protests. So in not quite half, but not that far from half, a protest does result in some sort of corrective action or ultimately potentially in a sustain to the agency. So with that, we're going to now start really targeting what we sold this as, which is the lessons learned. And I think it all comes down to, let's understand through the current protest what issues or mistakes prevent offers from winning a contract or cause the GAO or COFC to overturn the agency's award decision. And as we talked about, it's important to understand the forums. We're going to be talking today about GAO and COFC cases because they're reported. Agencies may take corrective action, but they don't report their cases, so we really aren't going to be basing our lessons learned off of agency-level protests. They have very similar standards of review, both of which are highly deferential to the agencies to give them broad discretion in evaluating proposals. The GAO limits review of award decisions to whether the agency's decision was reasonable, consistent, and in accordance with law, regulation, and the terms of the solicitation. GAO doesn't reevaluate proposals, and the protester's mere disagreement is not a valid protest ground. And the COFC has a similar standard. It'll only set aside an award decision if it's arbitrary, capricious, and abuse of discretion or otherwise not in accordance with law or without observance of procedure. And the focus is that the government's award decision have a rational basis. By way of experience, I would say that GAO, because it's an administrative process where any sustain has to be supported by 2 additional reviewing attorneys, they are much more deferential. At the Court of Federal Claims, you have federal judges with their own minds and their own independence, and the only precedence they're going to recognize is at the Federal Circuit, Court of Appeals, or the Supreme Court. So they have a lot more discretion to weigh in and determine how much discretion to give the agency. So with that, I'm going to turn it over to Caleb for our very first lesson.
Thank you, Becky. Good afternoon, everyone. As Becky said at the beginning, my name is Caleb McCallum, and I'm an associate here at Venable who does a mix of commercial litigation, most of it involving government contractors, and sort of bid protests and other purely government contracts work. I'm going to start us going through our first few lessons learned here today. We have picked out several recent bid protest decisions that we feel reflect some useful lessons that you might be able to apply to help you successfully navigate the proposal process, or if it comes to it, help withstand or win a protest. So our first lesson today is understanding what the government actually wants. I have 2 cases here to discuss. The first one is NECA Technologies. And in NECA, the protester argued that the Army Corps of Engineers applied unstated evaluation criteria, among several other grounds. And the fundamental issue that NECA argued was that NECA was disqualified because the evaluator said that they failed to show relevant corporate experience in, quote, preventative maintenance. Well, the term, as NECA argued, preventative maintenance, doesn't actually appear in the solicitation, but the GAO agreed with and sort of largely adopted the agency's argument that when you actually looked at it, something like 75% of the entire EWS could be considered preventative maintenance. So this wasn't an unstated evaluation criteria. This was more that NECA's proposal really missed the point. They didn't receive the award because they failed to show the government that they understood what the government was actually looking for with this particular situation. Solicitation, excuse me. In a very similar case to NECA, while NECA dealt with corporate experience, Facility Services Management dealt with the work history of a required key person, the operations and maintenance supervisor. Here, kind of like in NECA, the protesters simply took the wrong approach. They proposed the supervisor as, well, strictly a supervisor, someone who would oversee and facilitate the work, and proposed someone who appeared to have a lot of experience as a manager, but did not have, or at least the resume they attached did not show the skills to actually do the work itself. So in other words, the government wanted someone who would or could actually get their hands dirty and do the actual maintenance work that the solicitation was looking for. And the GAO denied the protest, and they held that this requirement about the experience and skills of the supervisor was in the plain language of the solicitation. And like the protester NECA facility services, they missed the point. Both cases show how important it is to truly understand what the solicitation is about and what the government is looking for. In both of these, the protester failed to recognize what the government was actually needed, and both cases also emphasize the need for the offerors to really closely examine the solicitation and to make a great proposal that addresses the needs outlined in the PWS, but also ensure that your people and you as the offeror have the required experience to do the work that is in the solicitation. What is interesting, though, is that both protesters argued that they did, in fact, have the relevant experience and qualifications, and they may have, but that's not what they put in the proposal. So if you don't give that information to the government, you are not going to win. So moving on to lesson number 2. Lesson number 2 has less to do with understanding the technical requirements of a solicitation, more to do with simply following the instructions. Now, I realize that following, sort of an admonition to follow the rules seems obvious, but there can be nuances to this. And I would suggest that CLAVAL certainly stands for the obvious proposition that you can't turn your submission in late. But when you read the solicitation submission rules, do you truly understand what you're required to do? So just real quick, the facts here I do think are important. The Navy required for a hard copy submission that could either be mailed or hand delivered. Each of those options had a different address. And the offeror did timely submit a hand-delivered version to the correct address. But the way the Navy's package intake processing worked, the package was not documented as received by the Navy until the next day. And the only evidence the offeror had of timely submission was a delivery confirmation provided by the commercial carrier who made the delivery. So the Navy said it was late, and CLAVAL was disqualified. This is obviously heartbreaking, and no one wants to lose a competition, but I think we could all agree we'd rather lose on the merits of our proposal rather than never getting off the starting line. And my bet here is that CLAVAL had never had to submit something in this manner before. Maybe it was either noted to the Navy or in hard copy or whatever the situation may have been for them. And so this was a unique or new submission process. So there's the obvious lesson here of triple checking your submission rules, ask the contracting officer if you need to. But I would suggest that a larger takeaway might be that if your proposal requires something new, unique, different, out of the ordinary for you, be extra careful and make sure you fully understand those rules to ensure against any problems or pitfalls like the one that CLAVAL experienced. Lesson number 3, I've got 2 cases to discuss. These 2 cases are sort of a different spin on my earlier admonition to follow the instructions. Here, the lesson is to not expect the government to fill in the gaps. And in the first of these 2 cases, in ACOM, this protest involved a number of different issues, but the one that's relevant to this discussion here had to do with the cost proposal relating to one of ACOM's proposed subcontractors. The cost proposal was missing some information and didn't provide some other information in the manner that was asked for by the solicitation. Now, the way the rest of the cost proposal was set up, the Army could have extrapolated the information they needed from what was in front of them. But the Army instead determined they could not do the price realism analysis because that information was not directly before them. So in other words, the offeror frankly didn't follow the instructions and provide all the required information. And so effectively, the GAO said you can't expect the government to do extra work to fill in the gaps. While the government could have figured out the missing information, it did not have to because you didn't provide the information in compliance with the solicitation. And I think the quote that I put up here from the decision is a really nice sort of one-sentence summary of what your obligations, the offeror's obligations are with regards to proposals. And it says, an offeror is responsible for submitting a well-written proposal with adequately detailed information which clearly demonstrates compliance with the solicitation requirements and allows a meaningful review by the procuring agency. So it's on you as the offeror to make sure that you are in compliance with everything. And the government can't be expected to sort of fill in the gaps, even if they could. And so that, I think, that second point about what the government could do is emphasized even more by Belita Tech. And here, the protester provided examples of 3 contracts to support the past performance evaluation, but they received a neutral rating on it because the evaluators could not locate more information on the past performance information retrieval system, or CPARS. And the key fact here was that the solicitation said that when evaluating past performance, the government, quote, may consider, end quote, past performance data from various databases. But the solicitation did not specify where the government would look. So in this case, the government elected to look on PPIRS and CPARS, but did not look elsewhere, such as SAM or PUPIS. But the GAO concluded that basically the government abided by the terms of the solicitation. And so while it's unfortunate for the protester here, the government did what they said they were going to do, and they were within, what their obligation, they were well within their obligations as stated in the solicitation. And so, both of these protests, ACOM and Belita Tech, I think show that so long as the government is staying within the 4 corners of solicitation, the evaluation will be proper. And, this actually really makes sense because, a lot of protests arise when the government starts to stray from the evaluation scheme, or at least allegedly strays from the evaluation scheme. And that's when the government gets in trouble. So, the government not filling in the gaps might be more of a reflection, is a reflection of the government just being careful and trying to be as fair as they possibly can to everybody. But to the point made by the GAO in the ACOM case, it's on you as the offeror to make sure that your solicitation complies, or I'm sorry, your offer, your bid complies with what is being asked for out of the solicitation. Which ties directly into lesson number 4, which is, don't expect the government to notify you of mistakes or weaknesses in your proposal. So, look, I realize that in many situations, clarifications and discussions do occur. The FAR has, all sorts of rules about negotiated procurements and those sorts of things, but not all do, and those rules may not apply to all mistakes or weaknesses that might be in a proposal. And a good example of this is the JJ Global Services case I have up here. And in JJ Global, they protested when they were evaluated as not submitting certain required information in their technical approach. And what happened was they exceeded the page limit. And I think we're all probably familiar with the page limit rule. Generally, the government will cut off if they say your technical proposal has to be 5 pages. Anything beyond that is essentially just torn out of the back of the packet and thrown away, and they don't even look at it. Well, certain information ended up on sort of those discarded pages. And however, that page limit violation was a result of a formatting error that was obvious and clear to anyone who looked at the document. And that information was there in front of the government, but it was on those extra pages. And because they were on those extra pages, that information was ignored. So, this is obviously very frustrating to the protester because the error was obvious. But this was not a situation of technical proposal going to 6 pages when it was 5. This was, a proposal that whatever format was created appeared to be within the limits, but somehow between drafting and submission, the government received something that was too long. So I think the big takeaway here, or a takeaway at least, is that your final white glove meticulous review is actually really important. My guess is that this is a weird formatting issue, converting something from Word to PDF, or some kind of wayward page break that slipped through and didn't show up until it was printed. In any case, these details really matter, and the evaluation team on the government side is going to strictly apply the rules in the solicitation, and they generally don't have an obligation to tell you about obvious mistakes. As you can see from the quote from the GAO here, it's up to the agency whether they want to do that or not. And they're well within their rights not to. So, it's on you to get your proposal just right and avoid any violations of the rules. So I'm going to turn this over to my colleague, Emily, but before I do that, I just want to let everybody know the CLE code for today's presentation is Victory 2020. Victory 2020. That's your CLE code for the day today. And Emily, I'll let you take over from here.
Well, thank you, Caleb, and thank you everyone in the audience for joining us today. As Becky mentioned in the introduction, my name is Emily Unash, and I'm a Senior Associate in Venable's Government Contracts Group here in DC. And like Caleb, I'm going to do a bit of a deeper dive into a few recent bid protest decisions and continue to discuss some of the lessons learned from those cases. So turning to lesson number 5, understand how to leverage your team. Prime and subcontractor teaming is a really common way for contractors to leverage the experience of their team's anticipated subcontractors. I think Caleb mentioned this earlier. It can be a way to help make your proposal more attractive to federal customers, particularly when past performance is a substantial evaluation consideration. Unfortunately, however, this is not always a winning approach, and there are definitely certain risks that you need to be aware of when considering how and whether you can best leverage your team. So one important factor in leveraging your team is just having a really clear understanding of whether and how the solicitation allows for teaming and credit to team members. So for example, there are some solicitations that will provide past performance or experience credit to a team member that can be attributed to the offeror, the prime contractor. However, not every solicitation contemplates or allows for this type of evaluation. So we're going to get into a case here and discuss the Red River Science and Technologies case. This is a recent example just demonstrating the potential pitfalls of this approach. The Red River case involves an Army Material Command procurement for the maintenance, supply, and transportation logistics services. And Red River proposed a significant contractor, the logistics company, and importantly, they also submitted with their proposal a very specific breakdown or division of labor to be conducted by Red River and their significant subcontractor. So Red River also included, according to the solicitation's instructions, one past performance reference for its subcontractor, and it was a reference that touched on all of the functional areas required by the solicitation. So it's a particularly strong reference, whereas the other references that Red River submitted for itself touched on various functional areas required by the solicitation, but Red River did not have any past performance reference that covered all of the function areas for itself. So Red River probably thought that it could make up for this fact because it had past performance examples from the logistics company that were both relevant and had great ratings under all the solicitation's functional areas. So they really thought, this is a great way to leverage our team and use their past experience to our advantage here. However, in Red River, that unfortunately did not win the day for the contractor. And in deciding the protest, the GAO clarified that when it comes to an agency's evaluation, consideration of a subcontractor's experience is not automatic. And in fact, for this case, it was not automatic. The GAO summarized, and this is a quote from the decision, the solicitation established that when evaluating past performance, the Army may consider the specific functional areas the offeror and its proposed subcontractors have performed, the areas each is proposed to perform, and the overall percentage of participation proposed for the offeror and any subcontractors. So following this permissive requirement in conducting its evaluation of Red River, the agency actually downgraded Red River's past performance evaluation because it found that it had used a particular teaming method where its proposed significant subcontractor was not actually going to perform the particular work area that its past performance experience supported. So to kind of break that down a little more for folks, essentially Red River proposed to be solely responsible for providing a particular function area here, the transportation logistics area, but it failed to provide sufficient relevant past performance references to demonstrate that it, Red River, could perform those functional areas. The Army actually noted in its evaluation that Red River's subcontractor, the logistics company, did possess that relevant transportation experience, but it concluded that notwithstanding that fact, it had no impact on the evaluation because the proposal did not state that that particular subcontractor would be responsible for any of the transportation logistics services. The GAO agreed with the agency, found that the agency got the evaluation right and was not required to credit all of the subcontractors' experience. So at the end of the day, this case is really a great lesson for how you can leverage your team and also the importance of just like submitting a well-written proposal that actually covers all of the solicitation's requirements and explains how, if you're leveraging your team, how each member of the team is going to fulfill the different requirements of the solicitation. Moving on to lesson number 6, proving competitive prejudice is essential. This is something that Becky touched on in her introduction, but it is so important and cannot be overstated that to win any protest, you absolutely must be able to demonstrate competitive prejudice. Competitive prejudice is generally defined as, but for the agency's actions, you, the protester, would have had a substantial chance of receiving the award. And the GAO, again, absolutely will not sustain a protest unless you can show competitive prejudice. So I'm going to go through a couple of cases that demonstrate this lesson, the first of which is the Inquiries, Inc. case. So this is an interesting case for prejudice because here the GAO actually agreed that in evaluating the protester, the agency failed to adhere to the solicitation's evaluation criteria and actually committed what we consider, flashing red, alarm bell signals, great protest ground. They committed disparate treatment, disparately evaluated offerors. So the GAO, just to break that down a little more, they found that when evaluating the awardee's corporate experience, the agency disparately evaluated proposals because it had assessed a weakness to the protester's proposal for a certain proposed corporate experience, but it failed to assess a weakness to the awardee's identical proposals. They proposed the same type of corporate experience, and yet the GAO only assessed a weakness to the protester and not to the awardee. So even accounting for that error, the GAO said, yes, this is disparate treatment. There was no reasonable ground for this assessment of a weakness to the protester and not to the awardee. But the GAO still found that at the end of the day, the awardee had a higher rated proposal and it was only slightly more expensive than the protesters. And the GAO essentially found that the protester, they couldn't find any competitive prejudice. It's significant in the Inquiries case too, so this wasn't their only protest ground, and this is often the case that protesters will allege multiple grounds of protest, but the GAO actually rejected each of the other grounds of protest, primarily on the merits. For example, the protester had alleged a impaired objectivity OCI, but the GAO found that, essentially found there's just no basis in the record or in the solicitation for supporting that OCI. And the GAO also dismissed other grounds protest as speculative. So at the end of the day, the GAO said, yes, you may have determined that there's one evaluation error here, and we agree that that error occurred, yet you're still unable to demonstrate, you're not able to raise the bar enough to show that, but for that particular error, that you would have received the contract award. So a similar case is the acuity exemplar case. And here, this is another example of a recent protest where the GAO again agreed that the agency's evaluation was in some respect unreasonable, but it still denied the protest for lack of prejudice. So in this particular case, the GAO found that the agency had conducted misleading discussions. So again, this is one of those protest grounds that, you know, we often think of as a great ground. It can lead to success. But here it goes to show, even if you have a great ground of protest, you still have to show prejudice. So in the acuity case, acuity had alleged essentially that the agency conducted misleading discussions with respect to its price. So it said the agency misled us into thinking that we needed to raise our price to meet the requirements for a particular collective bargaining agreement for the incumbent workforce. And during discussions, the agency had told the protester that they were concerned about the rate that they were proposing, and even mentioned a particular rate per an hourly rate that the protester might aim for. But they didn't make this a mandatory change for the protester. And at the end of the day, the protester ended up raising their rate up to the level, and they lost because the awardee had a slightly lower price than them. But even notwithstanding that fact, even though the agency found, yes, there was some misleading discussions here because the agency shouldn't have provided a particular rate for you to aim for as some sort of requirement. But at the end of the day, the GA found that there was no competitive prejudice. So we'll move on to lesson number 7, be mindful of business decisions. So I'm only going to cover one case here, but keep in mind, I mean, there's any number of business decisions that you make when preparing your proposal and, you know, even deciding whether to submit a proposal. And you have to keep in mind kind of the difference between what Caleb was originally talking about, you know, make sure you follow the solicitation's instructions, make sure you understand what the agency is asking for, and your own business decisions. So in the quality control case, GSA published a solicitation that was seeking maintenance services at a variety of federal facilities in Montana, and a number of offerors had submitted proposals here. And GSA conducted discussions and determined that both the awardee as well as quality control had proposed certain prices that were deemed to be unrealistically low. And in this case, both offerors ended up raising their prices upward. And following the revisions to their proposals, GSA awarded the contract to Phoenix and not to quality control. And they found that Phoenix had a slightly higher technical rating, and it also had a slightly lower price than quality control. So quality control, you know, understandably upset, they said, well, you know, both of us had to raise our prices upward. You told us, agency, that we needed to raise our price in order to make our proposal acceptable. And so they brought a protest, in this case with the Court of Federal Claims, and they argued misleading discussions. And essentially they said, well, the agency the agency misled us by requiring us to raise our price. So the court disagreed that there was any procurement error here and essentially said that even though quality control obviously felt some sort of pressure to raise its price based on these discussions, that the discussions themselves were not coercive because, importantly, quality control was still free to make a business decision as to how to respond to the agency's discussions. They could have decided, and they ultimately did decide, to voluntarily adjust their proposed price upward, but the court found that quality control could have responded in a different way, such as, for example, just by supporting their existing price. And quality control argued against this and said, well, you know, GSA didn't notify us that we could have provided any additional proof supporting our price. But the court rejected that argument and still said GSA was not required to explain to you how you could correct or address the concerns that they stated in their discussions. It was a business decision on the part of quality control how to address those concerns, and by choosing to raise their price, quality control ultimately lost the competition because they were just a little bit too high. So the takeaway from this case is remember that when you're addressing an agency's concerns, assuming the agency does not specifically direct you to respond or alter your proposal in a certain way, you are required to make a business decision as to how to best respond. And again, that business decision, it could come out in your favor, but at the end of the day, that's a risk that you are taking on as the offeror. And now I'll turn it to Becky to discuss when to submit your protests.
Thank you, Emily. And I'll also mention to everybody online, if you have questions, please feel free to type them in. If we have time, we'll get to them, but more likely we can always email you after the presentation if you have specific questions that we didn't get to. Knowing when to submit your protest is so important because if you're untimely, you're out, and you tend to be out fairly fast. So I tend to think of it in the pre-award context for solicitation and proprieties and also the post-award context. Pre-award, the rule's really simple in all jurisdictions. You've got to submit, if there's a known ambiguity in the solicitation, you need to submit that before the time and date set for submission of proposals or you're late. And late means you get, no matter how good your protest grounds were, you're out. Another tweak on that is that the GAO, if the agency changes after proposal submission, if for some reason the agency changes solicitation requirements after that date and it does not provide any opportunity for resubmission of a proposal, then you have 10 days after the date of the amended solicitation. That's pretty unusual context. I don't have any case law for you on it, but just know that that's out there at the GAO. The other issue that you're dealing with is one, can you even submit a protest? That's timeliness. The second issue is when do you need to submit in order to get an automatic stay of award? And so for a pre-award protest at the GAO and at the agency, what the stay is we're not going to award to anybody, but it doesn't prevent them from going ahead. If you protest the solicitation and propriety, just focus on the solicitation. They can't award to anybody, but they could still go ahead and require submission of proposals, and they can still go ahead and evaluate people and have an offer pending. Sometimes they do, sometimes they don't. And the other rule is there's never any automatic stay at the COFC, and that's true both pre-award and post-award. So why is this important? Well, it's important because a lot of people are fearful about going ahead and challenging ambiguities because they think they're going to give away their solution. But there are a lot of pros to it. And as an offeror, you want to make sure that you are competing on the same basis as everybody else. So if you're worried that an ambiguity might mean that somebody with greater information about what the agency wants can come in and the agency favors their position and not yours, you might want to clarify in the form of questions. There's usually a period of question and answer. Even if that period of question and answer is passed, you might as well kick it to the agency and see what they say. The agency might change or clarify its approach. We've had agencies do that before, and then that also allows you to understand what you need to submit in your proposal and how you need to price the risk and whatever the agency says. The risk, though, is you do have to make sure that it's not, the question that you ask is going to be distributed to all offerors, and you want to make sure you're not revealing your specific proprietary approach to anyone else. Most questions can be addressed without raising that approach, and I generally, depending upon the facts, weigh in as a pro and go ahead and would suggest clarifying. Also, the clarification might not come back the way you want it. That's always a risk. And the final risk is that if you've asked a question and the agency hasn't answered it, it certainly suggests that that is a patent ambiguity, and your duty if the agency does nothing is to step in and protest. But I've also seen the GAO and agencies be more gentle if the agency totally ignored it, depending upon how the question was written. So those are the pros and cons for you to weigh in terms of whether to do it. Now, the other issue comes up is if you have, you're excluded from the competitive range, the regulations give you the opportunity to ask for a pre-award debriefing or a post-award debriefing. Always ask for the earliest debriefing possible, because you've got to file no later than 10 days after the basis of the protest is known or should have been known. And while most people get information from their debriefings for the first time, you never want to have the agency be able to say, oh, you're pulling a basis of protest from something that you knew about as soon as you heard that you didn't get that award. You would have known. So you avoid that if you ask for a debriefing as early as possible and you take the debriefing the first date. And then there's no strict filing deadlines post-award or pre-award, really, at COFC except for solicitation ambiguities. But delay in filing might impact your remedy. Sorry, I realized I didn't advance the slide fast enough there. So then we're going to go to post-award issues at the GAO and the agency. So the answer is it depends upon what your solicitation is. If you have competitive proposals, which includes FAR Part 15 procurements, and also task order awards typically fall under this, then your time to file is no later than 10 days after the basis of the protest is known or should have been known, whichever is earlier, or within 10 days after a required debriefing is held. And debriefings, again, are only required for competitive proposals. They're not required for Federal Supply Schedule FAR Part 8 procurements. For FAR Part 8 procurements, all you're going to get is a statement of the basis of award, a brief explanation of your award. It's not a debriefing. A debriefing only happens with competitive proposals. So if you're in a FAR Part 8, if you have a Federal Supply Schedule and other non-competitive proposals, you must, to get an automatic stay of performance, you must file within 10 days after contract award. You can still file 10 days after whenever you learn about what the basis of your award was, but you won't, unless you meet that 10-day window after contract award, you won't have an automatic stay of performance. And what we've seen is that agencies play games with this, and they will sometimes, in the Federal Supply Schedule, withhold any statement of award until after that 10 days is already passed. The other fun fact is that there are GSA contracts that aren't FAR Part 8. If they're competitive proposals, which they typically are, if they're not FAR Part 8, then they follow the rules for everybody else, and they don't always know that. So we've seen agencies buying off of GSA multiple award contracts withhold a debriefing till later, thinking that it's FAR Part 8 rules and be wrong. So these are very technical, complicated rules in terms of timeliness. The best thing you can do is, personally, you're going to need a protest attorney anyway. Get somebody involved as soon as you hear you didn't win. The longer your counsel has to address any potential protests that you might have, the better, and also make sure that they're able to understand what those rules are to make sure they hit the timeliness requirements. All right. Of course, the head of the contracting agency might override an automatic stay at GAO based on best interest or urgent and compelling circumstances. You can sometimes protest those decisions, but sometimes people then just move to the Court of Federal Claims if it's a protest that can be heard by the Court of Federal Claims. Okay, we have an American Systems Group. There, the protester contended that the agency capriciously selected the deviation factor for assessing price realism. GAO found that the argument was an untimely challenge to the terms of the solicitation. And I chose that one because things that you might not think would be challenges to the solicitation, the game for interveners counsel and the agency is to take whatever protest ground you might have and see if you can turn it into an untimely challenge to the solicitation. So make sure you don't include any of those in your protest grounds. So with that, Emily and I are going to talk about key takeaways for submitting a winning proposal. It's really just a summary of everything we've already talked about in terms of the lessons learned. I'll take the first few and see if Emily has any, and I don't see any. We understand there's one question on FAR Part 16 and how it might affect your analysis. I'll defer to Emily to answer that question, and actually I think I'll turn it over to Emily right now.
Thank you, Becky, and again, thank you everyone for attending today. We don't have to go through all of the lessons learned, but please feel free to reach out to us after the presentation if you have any questions. With regard to FAR Part 16, generally the lessons learned that we've provided today are generally applicable across the board. I mean, as Becky mentioned, particularly when it comes to timeliness, there may be differences between FAR Part 8 and FAR Part 16, as well as differences if you choose to go to the GAO or the court when it comes to timeliness. And there may also be differences with respect to whether an agency is required to conduct discussions or how they would go through that process. But in general, the lessons learned that we've provided today should broadly cover federal procurements and hopefully give you a good roadmap for ways in which you can submit a stronger proposal, and should it come down to it, ways in which you can submit a strong protest or understand how to best defend against a protest. And with that, I think we are running up on the time limit. I guess we may have one more minute to check and see if we have another question. A con that an agency may identify. Why is it a con that an agency may identify a patent ambiguity? Becky, do you want to take that one since you've worked from the agency side as well as outside counsel?
And I didn't quite catch the question, and I didn't see it on the list. Can you restate it? Sorry.
Yeah, of course. So the question was regarding ambiguities prior to proposal submission. Why would it be a con that a question may identify a patent ambiguity?
Oh, well, the point, that's a great question, actually. Why is it a con? Yeah, it's only a con because if you're not willing to submit a pre-award protest over that question, and if you think it's a close call as to whether it's really a patent ambiguity or not, you might decide not to even ask it. Because if the agency doesn't answer it, you've basically labeled it by asking it and not being told a patent ambiguity. Now, as I told you, I err on the side of asking those questions to give the agency an opportunity, especially where it's going to make a difference in what I'm going to propose or how I'm going to price it. I'm going to want to know anyway. And you can deal with the patent ambiguity later, and you can figure out whether you want to do a pre-award protest or not later as well. I saw also a question, if the agency delays debriefing beyond the 10-day stay period, will GAO grant a stay if the company protests after the debriefing? And the answer is, yeah, I mean, if you're in a competitive procurement, you get 10 days, so you get 5 days after the debriefing. If you're, so the only time you get a debriefing is competitive proposals, and the standard there is 5 days, it's not 10 days. But you get 10 days after you knew or should have known of the basis, which is 10 days after the debriefing, is when you measure the timeliness for award. So I know those are confusing concepts. There's one standard of timeliness that applies to can you file the protest, and another standard which is will you file and also get an automatic stay. That automatic stay is so important because you don't want another contractor performing if you're going to protest. Hopefully that answered that question. There's another, I'll go ahead and just continue answering the questions if that's possible, or we could also email people. Emily, did you have something you wanted to add?
I was going to add, so timeliness, like Becky said, can be a really complex topic, but it's also going to depend in part on whether your debriefing was a required debriefing as to when that clock is going to start to run. So whether it's going to start to run after your initial debriefing, or if you are entitled to an enhanced debriefing, the clock won't start to run until the debriefing is actually closed, which would happen after you've had an opportunity to submit additional questions to the agency. Those are all, you know, the answer to timeliness is going to really depend on the type of procurement and whether or not a debriefing is required. So those are certainly questions that outside counsel will want to take a close look at, so that we make sure that we submit a protest in a timely manner and one that will help you achieve the CICA stay.
Yeah, great point about the enhanced debriefings. Regarding questioning and ambiguity, okay, I've got the con, sorry, that one. If a solicitation comes out under FAR Part 16, how does this change anything discussed today? Well, we haven't really covered the thresholds for protest of a FAR Part 16 task order. But first of all, you can only go to the GAO for if it's the contract in general, it's different. But if you're protesting a task order, it's only available at GAO, and it's only available at protest is only available at certain thresholds.